A report came out that a conservative majority on the United States Supreme Court is ready to overturn Roe v. Wade and uproot decades of precedent affirming a woman's right to an abortion.
That's Chuck Schumer speaking about a leaked draft of a court opinion originally obtained and reported by Politico. The draft, which was circulated among justices in February, suggests that the court is poised to overturn the decades-old decision on the right to abortion. Shortly after the leak, the Supreme Court released a statement confirming the document's authenticity, but added that it did not represent a decision by the court.
What we're seeing is a snapshot, and it could change, even though it's written in this very polished way that makes it look like a final opinion.
Writing an important legal opinion, which is going to have an effect on the whole country, takes a bit of time.
The leaked draft represents one step in a process that can involve months of deliberation. Here's a look at how the Supreme Court makes decisions on cases and how their rulings affect lawmaking in Congress. Once the Supreme Court accepts a case, justices review briefs and hear oral arguments from both sides. In December, the court heard oral arguments for Dobbs v. Jackson Women's Health Organization, a case that considers a state law in Mississippi seeking to ban abortion after 15 weeks. As part of the case, the court is considering whether Roe v. Wade should be overruled. Within days of an oral argument, the justices hold a private meeting, known as the conference, where they explain their views on a case and take a straw vote, or preliminary vote, on the ruling. The senior justice in the majority decides who writes the court's opinion, which is a written explanation of what they decided and the reasoning behind it. In this case, Justice Samuel Alito was assigned to write the draft.
A majority opinion of the Supreme Court decides what the law is in the United States. It's the last word when it comes to interpreting the United States Constitution.
The majority opinion is the only one that holds legal weight, but justices can write individual opinions explaining their stance. Those who agree but have additional ideas can write a concurring opinion, and those who disagree can draft a dissenting opinion. Those opinions circulate through the court, and justices decide whether or not to sign on to them. This process can last several weeks or months. During this time, they give feedback on the wording of the opinion, and the document can be edited.
From people in the majority, they're going to be saying what they like, what they don't like, what they want to see emphasized, what they think is going too far. That kind of thing. And they'll send notes or corrections. They'll make suggestions. Sometimes during that process, a justice can lose a majority.
While it doesn't happen often, justices have changed their minds while the opinion was being drafted. In 2012, Chief Justice John Roberts initially voted to strike down the Affordable Care Act, but ultimately came to see the law as constitutional. That's what changed the outcome to a 5-4 vote upholding the statute.
Things can change up until the last minute, until the court officially, formally, publicly releases an opinion. It has not made a decision.
At least 5 out of 9 justices need to sign on to approve the opinion. The draft is kept completely private until this point. Then it is released to the public and treated as constitutional law, which federal and state legislatures are bound to follow.
Sometimes when the Supreme Court makes a decision, there is a reaction, and Congress takes some steps to respond to what the court has done.
If the draft opinion in Dobbs v. Jackson Women's Health Organization holds, it will be the rare instance where the court rescinds a right it previously has recognized.
What this decision is purporting to do is to take away a prior Supreme Court decision recognizing a constitutional right, and that constitutional right restricted what legislatures could do, be it state legislatures or Congress.
If the majority of justices sign on to the opinion, abortion restrictions that have previously been unenforceable under Roe, like those in Florida, Texas, and Michigan, could start being enforced. Some states could act to preserve the right to reproductive choice. Lawmakers in New York and California said that they would push to amend their state constitutions to cement existing laws that protect abortion rights. Senate Majority Leader Chuck Schumer has stated Democrats' intention to codify Roe v. Wade at the federal level, but any bill faces major hurdles in a divided Congress.
It is my intention for the Senate to hold a vote on legislation to codify the right to an abortion in law.
If the Supreme Court were to overrule Roe versus Wade, that's a kind of unusual situation because, it's very hard to think of a time that the court recognized an individual right and then took it away And then people who still wanted that right had to enact it legislatively.
The court has until the end of June to make a final decision, and experts expect that abortion will be one of the final rulings before the court takes a break.